question is that the motion be agreed to. Raymond Ho.
I must congratulate Minister Maurice Williamson on his success in introducing this bill through urgency. If passed without going to select committee, and I guess that's what the urgency is all about, it will have to be the 21st bill, Mr. Speaker, so far to have gone through Parliament under urgency, with no select committee stage under this National Act government. In that regard, my congratulations should be read in inverted commas. Labour would have supported this bill. We called upon National to agree to allow the bill to go to select committee so that it can receive public input. It is unfortunate and it is regrettable that the National Act government refused to do so. We have no other option but to oppose this bill. National is continuing a habit of rushing laws through all stages under urgency. Rushed law is often poorly considered and has unintended consequences. It is also interesting to note that national MPs have also developed a habit of taking short calls. It is fitting for me as Labour spokesperson for statistics to report some statistics that upon my observation that on average national MPs would only take a 3-minute call out of a 10-minute speech and a 1.5-minute call out of a 5-minute speech. No wonder they are so passionate about ramming through legislation under urgency. So on one hand, the national government is moving at a glacier pace in finding out a plan to grow our economy. But conversely, they are moving very fast and are so fond of rushing through bills under urgency. No wonder their partner, the ACT Party, is such a climate change denier, because they are equally slow and moving at a glacier pace when attending to issues concerning our economy. But in a similar vein, they move rather swiftly in rushing through legislation under urgency. I want to reiterate, however, that Labour agrees with the policy objectives of this bill, but we cannot support the way the government is seeking to rush important constitutional changes through Parliament without giving the public a chance to have their say. To those who have read my media statement and the subsequent Red Alert blog on 25th February 2011, would appreciate that I supported the government statistician Jeff Baskamp's decision to not hold the March the 8th census. I supported the decision from Statistics New Zealand as we as a nation turns our efforts to help the people of Christchurch through their darkest hour. I also sent my best wishes to Census staff based in Christchurch at that very traumatic time. One commentator, whose name is conveniently to be unpleasantly Odo Referus, did make a very interesting point, and I quote, "I can understand the decision, but I am intrigued about the mechanism. The Statistics Act seems pretty clear about holding a census every 5 years, and 2011 is the 5th year, so it's a legal requirement. I know the government is now looking at the legislation to permit this postponing of the census, but cancelling the thing by executives and without that legislative authority seems to sail close to the modern case. I am not litigating the actual decision, just wondering about the constitutional necessities." Close quotes. I agree. I'm also not litigating the actual decision, but I was left wondering about the constitutional aspects. There are other aspects, however, which I wish to touch upon at the first reading of this bill. Firstly, there is an increasing demand for statistical information from iwi as more treaty settlements are agreed. Statistics New Zealand is working with iwi to identify what type of statistics will be most useful for collective management of transferred assets. I wish the relevant stakeholders, such as iwis and those parties involved in those settlements, to have their say and to refer to a select committee rather than ramming through an urgency is the most appropriate way to achieve that. Secondly, and more relevant to the minister responsible for this bill, there are some operational issues with Statistics New Zealand, and rushing through urgency without probably addressing those issues would leave the stones unturned, and it is not fair for Statistics New Zealand. In his response to the Standard Estimates questionnaire, the minister notes that, I quote, "The statistical system has lacked coordination, coherence, and prioritization," end quote. There is $17.685 million sought in 2011 to 2012 for the coordination of government statistical activities. Statistics New Zealand is responsible for leading the official statistical system. The minister's statement would lead to more questions, such as, in what way does the official statistical system lack coordination, coherence, and prioritization? What will be the key challenges for the official statistics system in 2011 and 12, and whether Statistics New Zealand will be ready for the 2013 census? Thirdly, I understand the information technology used by Statistics New Zealand is aging and needs upgrading. When will the IT systems be upgraded? What will the total cost of the upgrade be, and what the kind of impact on the 2013 census? And fourthly, there are some debate as to whether we should hold census every 10 years or every 5 years. Without a select committee stage, we won't have the opportunity to have those issues addressed. And just like, and as the minister just confirmed, that this bill will not good enough to address those issues. From the regulatory impact statement by Statistics New Zealand, we know that to defer the March 2011 census to March 2013 and 5 yearly thereafter would be incurring a cost estimated at $54.5 million plus the $18 million not spent on the 2011 census. So, Mr. Speaker, from constitutional, contractual, operational and financial aspects, there are solid reasons for this bill to be referred to Parliamentary Select Committee, and for those reasons, Labour opposes this bill.
John Hayes.